Okay, hello everyone. First, this is a panel about big data and tort law. Sorry that I just joined you now because I had 6 hours teaching this morning and I couldn't make it. I'm sure it was a great debate about many issues, and this is going to be about
it wasn't the same fun.
And this is going to be about torts. And right on time, I'm happy to introduce Professor Ronen Avraham from Tel Aviv University. He was prior to Tel Aviv University in University of Texas, and University of Northwestern. His main areas of research are insurance law, torts, contracts, medical malpractice, and lots of law and economics. Ronen is going to talk about discrimination, right?
What about
discrimination?
Hey,
and,
I'm trying to find my talk. Here it is.
Okay, and the floor is yours. You have 10 minutes, and then we're going to have a discussion just after each of the speakers, because Ronen will have to leave. He needs to teach. So that will be the arrangement for this panel. Ronen,
thank you. I'm sorry for being late. I just came from teaching, and at 4:10 I have to go again for another class. So I apologize.
People will believe you that you're working hard.
Yeah. Okay, so big data is increasingly viewed as a strategic asset that can transform the healthcare system through its use of powerful predictive technologies. However, it has been argued that big data, while enhancing our ability to make evidence-based decisions, does so by inadvertently setting rules and processes that may be inherently biased and discriminatory. So I'm going to talk about big data and discrimination. Critics argue that these rules or algorithms may perpetuate biases and reinforce built-in assumptions. In other words, data mining can inherit the prejudices of prior decision makers or reflect the widespread biases that persist in society at large. It has been argued that these algorithms will mask invidious discrimination, undermine democracy, and worsen inequality. In contrast, others have argued that we're not on the verge of an apartheid by algorithm. True, the age of big data might indeed lead to decisions that unfairly favor one race over others or men over women, yet any fair assessment of algorithm must be made against their alternative. Algorithms are certainly obscure and mysterious, but often no more so than the committees or individuals they replace. The ultimate black box is the human mind, it has been argued. Therefore, some argue that the consciously racist or sexist algorithm is less likely than the consciously or unconsciously racist or sexist human decision maker it replaces. And that the good news is that there is a solution to this problem, and the solution lies in a kind of algorithm affirmative action. This would require training algorithm on data that includes diverse communities and continually assessing the results for disparate impacts. I want to argue, so all this is what other people have argued. I want to argue that big data is not going to solve the hardest questions about discrimination, which are identifying what is distinctively wrong about discrimination, how to identify it, and how to fix it. Algorithms or algorithms' affirmative actions are not going to be able to tell us whether charging men and women different healthcare premium is just, or whether charging the old and the young different premium is just. And those are the easy questions because they deal just with money. Consider the harder questions of treating people from different races or genders differently because big data suggests one race is less likely to respond well to an expensive treatment. Is it discrimination? If yes, is it a wrongful discrimination? If yes, what is the appropriate fix? Is it leveling down everyone to poor medicine? Providing tax advantages to the race harmed by big data medicine? The more general question is, of course, how to balance notions of equality with concerns about effectiveness and efficiency of medical care. The age-old debate between deontologists and consequentialists is not going to be resolved by algorithm. However, just like autonomous cars force us to think harder on the trolley problem, because algorithms about which people to kill need to be programmed into these cars, so does big data will force us to think harder on questions of discrimination, only that now the stakes will be clearer. That's it.
Thank you very much, Ronen. So now we have a few more minutes for discussion.
So how would that play with big data, kind of big medical data, the kind of please continue your argument and apply it to big data more specifically.
So I think the stakes will be clear. That is, it will not be a theoretical question whether we prefer to provide, I don't know, to save 25,000 men a year versus 5,000 women a year. Hypothetically, it will become very clear what we can do to save or treat people of different genders, races, ages, etc. So I think the stakes will be clear, and we will not have a choice to just continue pondering about those questions and just talking about them. We will have to prescribe formulas and solutions. Just like, as I said, autonomous cars force us to resolve the trolley problem and not just talk about it for decades.
How would you translate that into the tort arena? I mean, these are general right concepts, which I completely endorse. But how would that translate into the tort? Thinking, the liability.
So one possibility is a healthcare provider commits a tort of discrimination when it, let's say, chooses the more effective route, that is to save more people of a specific gender or race over being more egalitarian. Is that a problem? So in Israel, for example, we have a specific law that forbids discrimination in the provision of public services. So it's an easy route. But even in the US, I'm not exactly sure how it might work, because in the US you have even more basic problems where courts use gender and race-based mortality and work-life statistical tables when they determine damages. So even that there is behind where Israel is. But anyway, at least with respect to countries that do have specific legislation that forbids discrimination in the provision of public services, then you have a cause of action, a possible cause of action for discrimination. And the question is, what is discrimination? An algorithm will not solve it for us. They will just make, as I said, the stakes clear.
Eran?
I think this raises the next question: how is this related to big data? I mean, if we are going to have a rule that a service provider must not discriminate based on this or that, then big data is just one input in the process of making a decision and discriminating or not discriminating. I think one of the arguments that we heard here today is that because we are concerned with the possible discrimination, we should forbid big data transfer, and that is not the case. So we should continue with big data research. We should simply prohibit discrimination by this service provider or another service provider. So it's not an issue of big data at all. It's an issue of discrimination at the level of providing service.
Can there be discrimination at the level of conducting the research? Let's say that in a few years' time we will find out that Maccabi or one of the other health service providers has conducted research mostly related to men rather than women. Okay?
Most
or mostly
of the
related
researchers
to.
Are like that.
Sorry?
Most of the medical research
Right.
are like that.
That was a hypothetical. Or let's say they have conducted more research relating, in Israel to Jewish patients rather than to non-Jewish patients or different ethnic origins, etc., etc. Can we require them, according to the club's anti-discrimination law and public service, to perform research on other subjects or diversify?
So I can say that, for example, in the United States, if you want to get NIH funding, you absolutely do have to include minorities and women in your research. And if you don't want to include them, you actually have to explain why you have excluded them from research. In this sense, the funder can decide on the
But if
on the
funder is
parameters.
correct-
Funder doesn't ask.
No, just a set, no, so I'm just giving an
Sorry.
example. So the United States has solved this issue by having the funder, the major funder of biomedical research require that in Israel, and the regulator could ask for that. I'm not aware that they have, but it's certainly a possibility.
But what I had in mind is a little bit different. I was curious about the following possibility that, I don't know,
We run vaccines on the entire country. Every child in this country gets some vaccine. And then we discovered that those vaccines, bottom-up approach, kind of big data approach. We discovered that those vaccines are kind of cost justified on some race or national origin, but are less cost justified on another, or less effective, or less something. And we're not trying to discriminate against anyone. It's just that the data tells us that this vaccine doesn't work on Ashkenazi children, but it does work on Sephardic children. So what do we do with that? And I think these are the tough questions that will become clearer in the era of big data, because we will just get it bottom up, and it will force us to finally resolve, at least for policymaking, the trade-off between effectiveness and efficiency and notions of equality.
That's the time.
What you're saying
Yes, go ahead.
I think that doesn't have to do with big data. We do that all the time. For example, the health policy. We decide to whom we give certain medications according to their liability or their potential to respond.
Right, but
to
right
those.
now we do it in-
And actually having more data will do it even better and bring it to a better on a need-to-know basis, and we know what we are doing using. So there isn't really it's not a big data issue.
I agree.
It's a cost-effectiveness issue.
We're doing it right now, but we're doing it at a much smaller scale, and we will do it very soon. And because it will become so prevalent, we will no longer be able to shelf it, this decision, and we will all have to. It will be part of the public debate about medicine, because it will be so prevalent.
But in order to avoid the tough decision, you prefer not to know.
No. Why is that so hard to? Let me take the privilege of the chair and add something to the discussion. Why is that so hard to accept? I mean, if we're talking about different industries, for example, banking, there's a Chinese wall between the orthodox banking and investment sections of the bank, right? And we keep it, and we don't want one department to know about what the other is doing. So, for example, if we're talking about insurance companies and we talk about sort of practices or new research that finds certain things, we might think of making these buildings, walls between the insurance companies and the medical research, where the insurance companies will not be allowed to access certain information because it will run under the model of risk distribution and other things. For example, it might impose sort of discrimination society. So why is it that bad? I know I'm radical on this.
No, you're not radical at all. And as long as what we are aiming to do is to prevent a practice that we want to prevent, such as discrimination by the insurance company, and we prevent access by the insurance company to the information, I'm fine with that, as long as we continue to encourage the generation of information per se and having it available to everybody else, because you're concerned with the side negative effect of having this information because it might facilitate discrimination by the insurance company, but you cannot
Or
predict
perpetuate discrimination.
or
in and of
whatever,
itself,
but you don't know.
stereotypes.
But you don't know what other benefits could come up from this information. In general, we should generate information for everybody to use, because eventually someone will find something useful to do with it.
Just a comment. I totally agree with what you said concerning what you've said. I don't think the effort should be about building Chinese walls and not giving them access to the information. It's making them not act upon them, because they access the information. But once they act upon them, they should be punished.
You could have said the same things about the banks, right? And it didn't work out. It turns out that if there are no Chinese walls, I mean, you cannot really say whether they acted on information or not.
But I think the question that Ronen just raised was that it's not going to be enough to say, like what you just said, they're not allowed to use it, because in some of the cases, these, the conclusions that emerge from the analysis would be, indicating a difference, and not always the difference is something that you should ignore when it comes to medical issues. For example, it's definitely the case. We just had a case like this recently in Israel.
Of the public, that's right.
Just a second. In Israel, a while ago, you may recall the case that Ofer Groskopf decided with the AIG insurance company offering its
roadside
female drivers.
Roadside services.
Exactly.
Yeah. It's not AIG, it's direct insurance.
Okay, maybe, sorry. And what they said was, among other things, is that men would prefer having their, all kind of benefits from the car insurance that are not related to
assistance.
Yeah, to assistance on the road, but rather to other issues that are less time consuming, such as taking the car to the garage or stuff like that. Yeah. So is there a difference there? It doesn't necessarily indicate that there's a difference. In this case, the court decided that that was discriminatory because it was based on stereotypes. I'm not sure that this is the case.
So just to clarify, I'm not against big data research at all. And maybe I was too quick in reading my own thoughts here, but I said that sometimes we'll have to ask, is it discrimination at all? And if yes, is it wrongful discrimination? Because not every discrimination is wrongful. And I'm not a deontologist. I definitely think we have to balance between the benefits and the cost. Discrimination is just one cost out of several possible costs related to big data, like privacy costs, costs associated with loss of privacy. But I'm just saying, my very modest argument is that it will be much harder to escape the question of discrimination than ever before, because it will become more prevalent, more salient, and we'll again, just like with the trolley problem, we'll have to decide who are we killing and who are we saving. We'll not be able to shelve it like we currently are mostly doing.
Thank you very much, Ronen.
Thank you.
Next speaker is Professor Yifat Bitton from the College of Management. Yifat specializes in torts, anti-discrimination, and critical egalitarian theory of law. Yifat.
Yeah, but at the same time I was leaving the floor to my dear colleague Ronen, who decided to discuss discrimination today. So I thought of is it? Oh, maybe it's going to be easier for others. Yeah. Good afternoon, everyone. I want to open with a brief story. And the reason I do it is firstly because I need to adjust a little bit because I wasn't here as well, and I'm not really very well familiarized with the issue of big data. I'm just starting to. I don't know. Oh yeah. Okay. Thank you. You're nice. You're being kind, Michael. And he should be because he's the one who pushed me into talking today. So the story is about me, and I was thinking about an expert to discuss some issues with him, and the first name that came to mind was my 13-year-old son, of course. And we discussed the matter together, and he was trying to explain to me, exactly how that works. If you go on Google, and then 116 other pages that you don't see are open, and the information is in there. And he was trying, to convince me to think about an issue that I was considered with privacy mainly. And he asked, what wouldn't you want others to know about yourself? I said, I don't know, searching on the web maybe for diet pills or something like that. Woman in me, sorry. And in any event, we were discussing this the whole time. My cell phone was in my purse. We were going on the road from Herzliya to Jerusalem. When we arrived in Jerusalem, he finished explaining everything to me, and I thought I got it all. And when we went out of the car, I took my cell phone in order to use the Pango, like the electronic parking system. And on the phone, there was an ad about dietary supplements, a shop in Jerusalem, and that was it. And in that moment, I was like, okay, what do I feel now? This is what I wanted to know. Like, what does it make me feel right now? I'm not just, clearly I was amazed, I was shocked, I was furious, I was frustrated. How do you conceptualize it? How do you translate it into tortious harms? How do you put money value on it? These are the questions that came to my mind the instant it happened, and that's why I thought that maybe this is what I should be focusing on. So the basic notion that I bring to the fore, of course, and probably it was coming up here over and over throughout the day, was that management and analysis of big data entails big risk to the end users. The risks it entails range on a matrix of personalized to non-personalized or maybe public harms, and on a tangible to non-tangible harm scale. That's how I think of it. Like if I'm trying to do like a basic mapping of the harms that utilizing and mainly analyzing and accumulating big data entails. Now, this is the first assumption. The other assumption, which is derived from tort law, is that generally speaking, the more personal, intimate, and tangible the harm is, the more compensable by current tort law it will be. And I emphasize current tort law because, the more I delve into the issue and the materials, it became clearer and clearer to me that we need to either develop a whole new range of tort tools to deal with the harms that are caused by big data analysis, or simply think of somehow bringing in other notions of compensations that are not necessarily stemming from tort law, definitely not from the traditional tort law, and my work has a lot to do, Ronen, has a lot to do with trying to take tort law outside its convenience zone. And with this material here, I felt like what I was doing is so ancient and irrelevant. Nevertheless, I try to stretch whatever it is that I'm doing with tort law in order to see how it can cover these type of harms. So first, I want to introduce some useful distinctions that I thought should be brought to the fore in order for us to think about the challenges that big data harms bear. So the first distinction would be between personalized and non-personalized harm. Whereas in non-personalized harm, I refer to cases in which one's interest is being harmed as an individual, as opposed to as part of a bigger crowd. Okay, so when I think about the category, this category pertains mainly to harm stemming from data collection analysis of the public. For example, think about Cupid, I think, analyzing the romantic habits of its users, something like that. So you're part of a public, even though your individual preferences are put in the data collection, and the analysis takes use of that, but you do not appear there as a person in that respect. So these are the non-personalized harm, and I think when it comes to these kind of harms, it is very hard to conceptualize it from a tort point of view and to think about it as a true harm, compensable harm in this respect. I can think about, some basic theories of tort law, like that brought by George Fletcher about some kind of agreed upon risks that society undertakes to live with in a manner that projects the fact that all actors involved are interested in in the actions, in the interaction, in the activity that causes the harm. And unless somebody was really negligent, namely acting unreasonably in using the data, then there's no reason to impose tort liability in these cases. So we can say in this respect that there's a general consent of people to take part in this big data collection, in the sense that as long as it's not personalized, they're in the game. And it's not just a matter of consent, it's just that the way I look at it, there's no reason for imposing tort liability in these cases. So that's the first distinction that I would make. The second one would be within the personalized harms, which is where I think tort liability should be imposed when they're caused. I differentiate between intimately personalized harms and non-intimately personalized harms. By intimately personalized harms, I mean cases in which a personalized information that was mentioned earlier pertains to peculiar and highly revealing characteristics of a person. Okay, consider, for example, revealing a person's sexual preferences as opposed to a person's foodie preferences. Okay, so there's something personal in revealing both details about a person and accumulating the information for both kind of items, but still at the same time, there's a true difference between utilizing the first type of information as opposed to the other, in a way that I think definitely the intimately personalized harm is much more devastating and harmful to the person than the former. In this respect, we can think about most in this category. Most harms would be imposed through an abridgment of the right to privacy of people. So I think this is a basic knowledge that I shouldn't go back to. It's clear that the main issue here is privacy, and here, of course, there are questions of whether the information was actively provided in a manner that I was actively looking for a supplement. Dietary supplement in Jerusalem, which is one thing, as opposed to the passive way of such an information being inferred from what I was doing, from listening to me talking to my son. So these differences should matter as a means to I think to assess the harm. So there's something more harmful, even though the same information is eventually revealed. At the same time, it is more harmful to a person to have this information revealed without having any intention for it to be revealed, even as opposed to a case in which the intention was maybe to search for something for myself, but I was looking for some kind of guidance from the internet when I was doing it like that. So maybe this is another relevant distinction. Also, I'm thinking about the personalized harm that can be maybe not very intimate, but at the same time very harmful. Think about, for example, the case of Target. Just a few months ago, the case was settled in the court of the Target, the retailer, having all of its data, its customers. I think it was around 100 million customer database that was hacked, and the information about credit cards and so on and so forth was sold and used and abused by others. And definitely in a case like this, you have a tangible harm in the sense that it is an economic harm or a monetary harm, better said, as opposed to intangible harms. But at the same time, it can range from very small harm to a substantial one, and it seems like the court in this case was unable to deal with the claim that was brought against Target on a regular, traditional tortious footing, and decided to set a fund to which money from Target would be deposited and distributed according to the specific customer's claims. But normally speaking, we may say that as long as the harms are tangible and non-personalized, and non-intimately personalized, probably they will be left uncompensated. An example for an intimate, personalized harm that is tangible but nevertheless that is non-tangible but nevertheless very substantial, and I think could be more easily addressed by traditional tort law tools, is, and again, Target is involved in this case. In the case of I don't know if you've heard of it, of a father going to Target and approaching them. Probably it was raised here before. So the idea that a pregnancy of a teenage girl is being revealed by Target to her father is definitely an example for how that kind of losses, even though they're intangible and caused by big data analysis, can be compensated by traditional torts. Probably time is up, so I just want to mention the other types of rights that can be infringed through that, and that tort law has learned to cover and to protect, like freedom of speech in cases where Facebook pages are being shut or being disabled for a few days, and so on and so forth. We have just in the NGO that I had has just taken a case like that to the court, and we were trying, to evaluate the harm there, putting numbers on the harm to freedom of speech, and that requires a lot of creativity. And the challenges are just emerging, and tort law should get ready to that second level of evaluation.
Thank you very much, Yifat. Our next speaker is Professor Dr. Gil Siegal, which has a medical doctor and an SJD, and he's the director of the Center of Health Law and Bioethics Faculty in ONO, and also he was and still is a member of the Virginia School of Law. Thank you very much, Gil. The floor is yours.
All right. Thanks for having me. I must say then, when this session was presented to me, I immediately thought, as a man of tort, and my mentor Amos Shapira is here, so I thank you for allowing me this knowledge in law. I was really thinking of hardcore tort law. So I do excuse myself for taking the discussion down to earth in a way. We tort people are really down to earth, so I apologize. We do deal with real people, bleeding, stuff like that, personal injuries. So I'm going to do that. So for those who are very familiar with tort law, my words might seem trivial, but it's going to be short. So don't worry. It's going to the harm and damages will be short. But I want to talk about the new implications of big data and medical big data on the tort, and especially on malpractice. And this is something which is essential because as we're facing the new wave of abilities, and as we know very well, abilities do create liabilities. And it is our role from this table and other tables, which are practical, empirical professionals, to advise our clients, advise the regulator, advise patients how to deal. So having this, these very theoretical discussions are extremely important. But that's the first level. And then come people like me, low-grade people who discuss about how to deal. Shelly sitting here, she's the legal advisor of Maccabi, so she needs guidance. What's the right, what's wrong? She needs to guide her peers what to do and what to do. So from that role, and I must say that in my capacity, I came late because I was doing my morning ENT surgery, and we work for the government, for the national IRB. Yifat Lab is the chairman of the Bioethics committee. So we actually are people around this table are really very much involved in the real life of healthcare. So again, bringing this back to tort law. Tort law offers a means to direct behavior in a changing environment. So as the environment changes, practices should change and should reflect what the law seems to be the reasonable way to deal with the new abilities. The sensible use of health data, especially big medical data, is something that will require a legal resolution. Now, if we have the tort law being turned into laws and regulation, that's one thing. But as we know very well, most of tort law is done in courts. So then we have all the big issues of what is reasonable, what is anticipated, what are my reasonable expectations, foreseeability, all the big terms that we know from hardcore basic 101 tort law. How would that apply to big data? Now, I should say another word, that big data is important, but with all due respect to big data, it's just a small branch in health IT. And health IT is a big branch of the IT revolution. So within that, we don't start from scratch. We do have a lot of things going on with the health information revolution. We have precedents, we have ideas that have been put to work, and I will try to do some of them very shortly. Again, this is I won't even be able to scratch the top of the iceberg. For tort people, we know that the big data and the use of abilities create liabilities, like I said. And if you just think, again, nice around this table where people fall down under, and us, we use common law, so it's easy for us to relate to duty of care, breach of duty, and damages caused by the breach of duty. Very easy, tuck, tuck, tuck. Okay, now when we do that, how does that translate into the big data world? So, and again, I might confluate that with the general ideas of health IT. So, the EMR, the Electronic Medical Records, we have a lot of things going on with that. So, big data can just nicely ride on that wave and on those resolutions. So, just think about the following issues that we must decide on. So the duty of care, for example. Now, as you know very well, the neighboring requirement, who's my neighbor, my legal neighbor, and who do I own a duty to? So if I am within the Maccabi's EMR system, and Maccabi now knows that I have penicillin allergy. So clearly, if I go to a Maccabi institution and someone gives me accidentally penicillin, then there's no question that Maccabi owes me a duty of care because I was in their system. But now in the big data world, I'm one of 2 million people in that data. Is there any duty of care towards me just for the mere fact that I was part of that data bank? Now, there's two ways to think about it. I'm not going to come with a resolution right now. We don't have to deal with it later. But that is the question where you see that the ancient question of duty of care suddenly emerged in the new clock and a new design, and how that should be decided on. Is there an expectation for duty of care? If I am party, Michael said, I'm giving my data. Well, so if everybody could sense that you're doing something, so what do you expect in return? We wrote I shouldn't say that. I wrote a paper with Mark Rothstein, which is the #1 scholar in healthcare law in the United States, and our paper was about the duty to notify patients about new advancement. It was a Newsom Law Review some 2 years ago. And our discussion was, okay, so you see a patient today, and you tell him, you can't eat marshmallow for 5 years because you have ulcerative colitis. And after 4 years, it turned out actually marshmallow is really good for your health. Now, do I owe my patient the duty of notifying him, well, actually, we changed the diet? Now, 20 years ago, you would say, no, there's a burden, I can't reach those little patients. Forget about it. Today, click of a button, 2,000 emails are sent in every fraction of a second. So you can actually reach all your patients. All my patients today at my Tel Aviv Hospital all had their emails in my files, all of them. Cell phones and emails. So connectivity is a non-issue. So the burden now becomes a non-issue, and therefore your duties as a provider are increasing. And don't be shy to say it. Yep, the IT revolution is changing and increasing in a way our duties towards our patients. The breach of duty. Now, as we know, once there's a duty, how do you define your duty is something extremely important. Now, the reasonable standard created by the profession is really pushed once you have the health IT at your disposal. So suddenly, first of all, just the availability of information changes your practices. So you can no longer shield, well, this is what I learned in Vienna in 1941. That's dead. Information is all available for you. If that is the case, and big data is out there, which multiplies your abilities as a provider to navigate and to change and to analyze and to come up with a resolution, then I will tell you that from a court resolution perspective, especially if you're dealing with a jury system, which make with a big fuss, and you convince them, if only they would click a button of the search query and they could have all the information, that's going to be an easier sell in respect to a duty or a breach of it. Okay, go ahead. No, he's the boss. You want to ask something? Yes. There's one question waiting in line, so we'll put that. Now, with respect to the damages issue, and we're going to talk about what is reasonable, what is not, how fast you need to adapt new standards, who provides standards of care in an endless world where there's limitless access to information. These are all changing. Again, it relates to the health information, but it really relates to everything. So that's very important for us to understand. So duty of care, breach of duty, damages. Damages. What are damages? So again, we heard from this side of the table, oh, they access my information. Gotta tell you, I hear those. All right, I hear it. But always when we talk about the damages, and I'm extremely, especially being provocative, because there's a very...
I said it's non-compensable.
Exactly. That's exactly what I saw. So if you want to quantify, and Israel, for example, is one of the only jurisdictions that actually accepted the dignitary damages as a cause for compensation, others rejected that because it's so immaterial, right? Why are you laughing?
It's not. It's not.
What? It's not what? It's not what?
No, we've done very good work.
Oh, yeah, okay. Israelis, yeah, we make it, yeah, of course, yeah. But you try to teach that at UVA, it's a hard sell. It's a hard sell. So what is damages? And again, the big data, what I'm afraid of versus what can I gain, and that really goes back to tort law. Because remember, tort law is basically about directing your practices, changing your routines. So if you wanted to protect the environment, yes, we created toxic torts because we actually wanted to create something. So how can we use tort law to actually, until now, what I heard was a lot of don't. Wait a second, maybe tort law is there to do, and we will create a different paradigm and different tools to actually allow us to harness the big data towards the benefit of the collective, and therefore the standards then should be adjusted, or maybe, for example, there will be waivers, there will be exclusions from liability in order to allow researchers and hospitals to actually not be afraid. Because remember, if I would be able to convince the jury, this hospital was a click of a button away from finding information, and they failed to do so, maybe there will be a cooling effect, where institutions say, you know what, I'm not going to create a database, because then I can just create to myself more liability. We are very afraid of cooling effects in tort, because again, like I said, tort is the way to signal what's the right way to work with. So maybe I'm not going to do anything unless someone provides me a guarantee, a shield from liability, and we have that a lot. Within the vaccine, for example, industry, which was mentioned before, manufacturers were giving a shield from liability. Otherwise, I'm not going to produce any more vaccines. So we have that precedents in the past. I think I need to finish, right? Yeah. So I was having fun, but okay, I'll finish here. I will just follow, so I'll have to come.
We'll have some Q&A.
Yeah, sure, no problem. So I'll just say, I was really enjoying it. Okay, so two more things. One thing is that everybody's talking about liabilities of the providers and the systems. And I'm putting on the table here, I will share I will increase dramatically the liabilities, the duties, and responsibilities of patients. We're in the era of the e-patient that are educated, empowered, enabled, engaged, and actually enthusiastic about their new role in healthcare. So yep, in liability and tort, we create a stronger pendulum movement towards patient being involved. And yeah, once you are involved, there's more liability on your part. And within the liability, not liability, responsibility part, yep, you might, will be a reasonable plea to say, give up a bit of your rights because there's a greater good at the end of the road, which is worth pursuing. Again, on a large scale, that needs to be parceled in. And my takeaway message, and again, sorry for being abrupt, some consequences. An active duty to harness IT capabilities should and is emerging. There's no doubt about that. And if not today, just tomorrow. It's easily foreseeable. A duty to facilitate cooperation amongst and between providers. I don't care if you're Maccabi, Leumit, Athena, I don't care. Once the data is there, there's an imperative to allow the big data to be endorsed, and we have people actually doing that from Ministry of Health. So I salute you for that, and we can help you with the tort abilities to make that happen. Even though it will be a hard sell, I acknowledge that. And claim for privacy breaches, which can be surmounted, should be assessed against the validity of the damages that, at the end of the day, might be lower than we expect, and the benefits greater than is currently perceived. Thank you very much.
Thank you very much. Sure, go ahead.
There were a lot of refreshing angles. I just wanted to say something that I sort of I practice medicine in Jerusalem, which is the capital of Israel. It's a cultural and economic periphery. And 2/3 of my patients do not have email and do not have internet access and cannot, so calling them e-patients is way far in the future. And I don't know what the situation is in Australia, but to assume that all of our patients are educated is really, I think, a far stretch. I think in the United States, the average literacy is of a 6th grader, and numeracy is even lower. I really think that saying, oh, there's an onus on patients now to run their own care, I think that's taking it too much to the extreme. And we really have to think about, how to do that. And I think one of our huge challenges is going to be I think we have to engage the public in this whole process, is how to do it and how to explain it, and it's not going to be easy.
You said that it's a hard sell.
No, but I'm saying, he said it's a hard sell, but also telling us, the patients are so wonderful. They're all like the people in this room. No, they are not at all like the people in this room.
Unfortunately, I have never said that. What I did say, and I think I got to be very clear, and I think it's a recurrent theme between you and me on that issue. What should be said is that we cannot keep our thoughts on your model of patients. Not 2/3. I completely reject that. 94% of Israelis have a smartphone in their hands. It's 70% of the population has a 12th grade education or above of that. So with all due respect to American standards, of course it's a society is dependent, but clearly we are moving in a very concrete direction to patients that are more engaged and more knowledgeable. Are we doing enough? Are they all Einsteins? No. But the theme is very clear. We're stepping forward towards their involvement and engagement. And it's very clear to see it in your patients. When I started to practice medicine in 1991, my patients had no access. Today, they come to you with the entire package. This is my temporal arthritis. Here are the last 50 articles. Read about them. Let's discuss that in our next meeting. That has changed. So is it all of them? No, but it's a growing portion, and it's okay to allocate them a greater responsibility.
This issue has come up in Australia in the context of duty of the doctor to recall patients or to check whether they've... but basically the approach there has been in terms of the court, sort of saying the duty's still on the doctor because the patient doesn't fully understand necessarily the significance. So if the doctor says go and have this test done and then the patient doesn't come but the test shows you've got cancer or something, then the duty's on the doctor to go. So certainly it's been looked at, but at this point, the way our courts are looking at it is the duty's still with the doctor, although I agree with you that perhaps as levels of education and knowledge and so on go up, it might change a little bit.
Our last speaker of the day, Assaf himself.
Okay, so I'm also we're both moderator and speaker, so
Yes,
Michael
so
will moderate me. Yeah, exactly. So I was also going into the details, speaking about the interface between big data and tort law, and I'm going to elaborate on some points. We'll see how many. So the first one is the way big data can alter and reshape the standard of care and the standard of treatments, both in terms of the nature of the treatment and its quality. And here's the question: how can the use of information affect the quality of care and tort liability standard? The effect of the databases can be in terms of revisiting what is reasonable. Treatments, once considered to be reasonable in light of the direct medical outcome, may be regarded as ineffective or even harmful due to information accumulated in the long run. Alternatively, ignoring benign or small risk symptoms may be considered unsafe and unreasonable in the light of long-term effects discovered through the big data analysis. Moreover, the use of big data may affect not only the quality of care but also the basic criteria and benchmarks that are being used for its assessment. New articles, for example, Professor Perrat from this faculty, suggest that big data might push medical treatment and legal standards that regulate it towards a more individualistic approach that is made possible due to the availability of information. Hence, they suggest a shift from the application of general objective standards to a more nuanced approach focused on the specific caregiver and its patient. Reasonable treatment, therefore, should not be assessed according to the reasonable person general standards, but according to a more subjective criterion, one that better reflects the correct and real needs of the parties. This subjective approach, focused on the therapist and the patient's relevant data, has many advantages. It reflects individual needs of specific patients and can accommodate these special needs. It is only made possible through the use of big data and access to it. An interesting point in this context concerns the establishment of the causal link between the negligent act and the harm in the context of tort lawsuit. Big data challenges the concept of the causal link in both the factual aspect and the legal aspect. This is especially true in situations where the tort system applies a regime of strict liability or no-fault liability. In other words, a regime where the tortfeasor doesn't have to foresee the harm or expect the damage, and it is enough for plaintiff to establish the fact that the defendant inflicted the harm upon him. In such scenarios, the factual aspect of the causal link can be easily and erroneously substituted with correlation between a certain phenomena or action and the inflicted harm. Indeed, correlation can serve as an important role in the process of establishing the causal link, but they should in no way be substitute for it. This should be remembered by both judges and jurors, because oftentimes the temptation to overlook the difference between the two is big. For example, the fact that some people who undergo a certain medical procedure, say X, turn out to have a certain condition, say Y, doesn't mean that X is the cause of Y. Even if X turns out to be wrong procedure, and despite the plaintiff's desire to see the connection between the two, and sometimes there is such a desire, the plaintiff should always be obliged to legally establish the fact that X is the cause of Y and that Y is the result of X. And of course, he should establish the fact that X was wrong. In a world where the plaintiff has established fault, usually under the negligence regime, things are even more complicated due to the fact that in order to win the case, the plaintiff must prove not only cause in fact, but also that the defendant could and should have foreseen the harm. The question of the ability and need to foresee the harm raises broader questions regarding doctors' obligation to foresee different types of correlations and consider them during treatments. Here, there are significant issues regarding the failure to use certain databases before providing a treatment. Is it possible to impose new duties on the medical system, such as an obligation to consult new databases in order to diagnose medical phenomena? Is it possible to require the formation of such databases, to permit others to access them? In this context, we should take into consideration not only the positive aspects of the use, but also the negative ones. The lack of desire of institutions to disclose information or provide access to it for the fear that such information may be used to prove their negligence in a lawsuit. Perhaps the growing phenomenon of defensive medicine will prevent the creation of certain databases to begin with, as it was suggested earlier, in order to prevent the exposure to lawsuits. Another interesting question is how big data affect the doctor's disclosure obligations. Availability of information and easy access to it will push towards the expansion of the required disclosure obligations and perhaps redesign or reshape them to the benefit of the clients by making the information more understandable and handy. Perhaps the entire process of disclosure will be handled by more professional bodies and not by the doctors. These bodies will become expert on the disclosure process and will create large body of information from different sources, and hence will be able to give the patient a better overview of the nature of the treatment. How do I have 5 minutes? Oh, okay. So I'll just go to another point. Maybe I'll have another at the end. So the next point is big data, informed consent, and compromising on one's autonomy, which is a sort of head of damage under the Israeli tort legal system. I would like to elaborate a bit on the issue of informed consent and compromising one's autonomy, two doctrines that have played a key role in the area of medical malpractice in recent years. They became central through the application of relevant articles in the Patient Rights Act, but also through the application of more general case law, through the expansion of the informed consent doctrine within the tort of negligence, and the development of new head of damages compromising one's autonomy that allow the courts to use the tort of negligence in the absence of traditional damage. I would like to warn against the mechanical application of the violation of autonomy precedents in the context of healthcare to cases in which information on patients was collected without their permission. Indeed, such cases, the right of the patient to make a decision on the matter was violated. But this doesn't amount to the violation of rights that occurs in the paradigmatic medical care cases. When dealing with medical treatments provided without the patient consent, we are dealing with the core aspects of tort law, protection of the human body. Treating someone without her consent used to be covered by the tort of assault or battery. The non-consensual touching of the body was protected by intentional tort and didn't depend on whether the treatment was for the patient benefit or not. Only later the emphasis in such cases shifted to the tort of negligence, arguing that not disclosing the risk of a given medical procedure is a breach of the standard of care, is made without due diligence, and therefore is negligent. This was part of a process of empowering patients and putting them on par with doctors, enabling them to make informed choices and protecting their autonomy no matter what the outcome was. The case of collecting information about patients without their approval is a different story. One can debate whether non-disclosure in this latter case is more or less severe, and I think it's less severe than the former. However, one should be aware that even though both cases of non-disclosure occur in the context of medical practice, they are dealing with different situations and therefore require a different analysis. While the paradigmatic case of non-disclosure in medical malpractice situation affect the medical treatment or its admission, the act of gathering information without disclosure is not relevant to the treatment as such and has no effect on it. The violation of the patient's right, if at all, is in the realm of invading his privacy. This indeed might turn out to be a very serious issue and significant violation of his right, but it is still a different kind of injury than the one inflicted, say, by non-consensual operation. Significant characteristics of the information gathering paradigm, such as the lack of physical harm to the patient and positive externalities from the collection of the information, might lead us to the conclusion that in this context we may want to reshape the duty of disclosure and its scope. First, because of lack of direct relationship between the medical treatment and the gathering of information. it will make it difficult to establish assault due to non-disclosure. And second, given the wide social interest in gathering of the information and the public goods it produces, it might be wise to examine this situation in the context of a more general law of negligence, which allow court greater flexibility and discretion in its application. Moreover, this strong public goods aspect might even lead the legislator in the appropriate cases to impose a regulatory duty on patients to disclose the relevant information and on the medical provider to collect it and even save it for future purposes without leaving it to the party's discretion. But what about harms these practices might inflict on the individuals? With this respect, one can expect negligence law to develop new duties that protect the process of gathering of the information and its use and the place of certain burdens on medical institutions regarding these processes. One might also consider the formation of a public compensation fund established for the purpose of compensating those who were injured in such situation where no fault could be established by society that believes that this gathering of information is important. Just a short example or analogy that I would like to make is to vaccination. And I think this case is similar to vaccination, as we heard before, because vaccination has a lot of positive effects on society, but it has also many drawbacks. I mean, side effects and other effects which it hurts, but it has also many complications. Still, in some cases, some countries impose a duty to get a vaccine, and in other cases, there is a sort of a punishment for not getting a vaccine. For example, you cannot attend schools without having these vaccines altogether. So if you compare this to the issue of collection and handling the information, collecting the information and handling it is less dangerous than the vaccine phenomena. And if it produces similar public goods in terms of better medicine, better knowledge, then we might impose a duty on both sides to collect the information, even if it is against their will, because this is for the purpose of the society, and we do it in other areas of law. So I'll stop here and we can just continue later on. Thank you.
Thank you.
Okay.
Including thoughts about this or other items that we haven't yet discussed. It's been a long day. So, Well, okay. Concluding comments. I will not even attempt to summarize anything. It's been a long day, and I think we have a lot on the table. It's pretty clear that we are quite likely to see more discussions in years to come in privacy, in torts, in ethics, in medical management and other related fields. So we hope we sort of kind of set the agenda for such discussions for the foreseeable future. We will have the video online at some point. We will also have a summary at some point. That's Eviatar over there. I will be circulating an email to speakers asking for a shorter version of your comments, you know, 2 to 3 paragraphs kind of summary, so that we can have it all online, so you know, the wisdom is not lost and can be curated, and others can enjoy that. Guys, thank you for surviving until the last panel. Appreciate it. Thanks to the Suffer Center. They're not here, so we can truly thank them, even though it's not just you know, to look alike. And to Sharon Vera Chaked, who's also not here, but helped organize everything that has been here today. Thank you so much, and see you soon.
Thank you, Michael.